Okay, we go straight back to Abuja, to the Presidential Election Petition Tribunal. Are they sitting at the Court of Appeal in Abuja? And we have Arise News correspondent Godfrey, who is on the ground there to fill us in on proceedings at that event, special event on D-Day. Arise correspondent Godfrey Eshemoge. Godfrey, are you there with us? Okay, well, what we have on the screen at the moment is the courtroom where the, counsel are seated. And then you also have some of the key personalities involved in the matter also seated. Earlier on, I cited the Vice President of Nigeria, Senator Kashim Shettima of the All Progressives Congress, APC, already seated in the courtroom. And some of the counsel on all the sides, the Labour Party, the People's Democratic Party, and the Allied People's Movement also seated in court. What we await is the commencement of proceedings. Well, it looks like their lordships have not yet entered the courtroom before proceedings will commence. But it looks like D-Day is set. Judgment Day, as it is otherwise called.
Electoral Commission. Senator Bola Tinubu. Senator Shettima, Kashim. All Progressive Congress, APC, respondents.
All due respect to the court, my name is Kashim Shettima, Vice President for the Republic of Nigeria, an independent.
My lords, the petitioners are not represented in courts.
Oh.
No. Okay.
Barrister Julius Abure, National Chairman, Labour Party.
They're representing
the second petitioner.
Okay. My lord, the second petitioner is represented in courts. Also, for the respondent.
May it please my lords.
By who?
Abure.
Abure Julius. A-B-U-R-E. Julius. For the second petitioner, my lord.
Yes, any other representation?
May Abamuchi Umbu, INEC National Commissioner, Chair Legal Services for the first respondent.
My lords, my name is Kashim Shettima, representing the third respondent. I'm the third respondent.
So, my lord, the second petitioner is represented. The first respondent is also represented here in court. The third respondent is present in court. Other parties are absent.
Who is also in court? Second respondent is in court, yes?
My lord, my name is
respondent.
my name Dr. Abdullahi Umar Ganduje, National Chairman,
Okay.
APC, representing the fourth respondent.
Okay.
Fourth respondent.
The fourth respondent is represented here in court, my lord. Other parties are absent. Thank you.
process of council they are a bit lengthy. So maybe you can just announce the appearances, but this is here. We record them after the
With respect, my lords, I'm Dr. Levi Uzoku. I appear for the petitioners, my lords.
yes.
Appearing with me are my brothers of the inner bar, starting with our Kalo SAN, Ikechukwu Ezechukwu SAN, Dr. Mrs. Valeria Janet Azinge SAN, Emeka Okoko SAN, Alex Ejesiem SAN, Peter Afoba SAN, and then members of the outer bar with us, 3 of them, starting with number 8, Chike A. Obi, Precious Uchendo, and finally, Igwekama Ubiora. Together, we appear for the petitioners, my lords.
Being appear with the iron eater today. The iron crusher.
He couldn't be accommodated to them.
Yes, first respondent.
If it pleases my lords, I am Sir Stephen Adehi. I appear with my learned friends of the inner bar, T.M. Inua, SAN, Al-Hassan A. Umar, SAN, Suleiman Olawale Ibrahim, SAN, and our friends of the outer bar appearing with us are Nasara H. Auta, Esquire, Aminu Sadauki, Esquire, M.A. Atta, Esquire, Susan A. Imrosi, Esquire, Jamiu Aguru, Esquire, and Martins F. Effa. We all appear for the first respondent. Thank you very much, my lords.
With profound humility to my noble lords, my name is A.A. Malik. My humble appearance is for the second and third respondent. Hello, my learned brothers of the inner bar. Appearing with me are Babatunde Ogala, SAN, Dr. Remi Olatubura, SAN, and Mutalubi Ojo Adebayo, SAN. And we also have our colleagues on the outer bar, namely my lord, Emmanuel Uwadoka, Esquire, Yinka Ajeni Fuja, Esquire, Akintola Makinde, Esquire, Julius Ishola, Esquire, and last but not the least, Taiwo Lakanu, Esquire. Great my lords.
Yes.
Good morning, my lords. I am Chief Dr. Charles Uwensi Edosawa. I make a humble appearance for the fourth respondent. With me, sirs, are Chief Adeni Akintola, SAN, Chief Afolabi Fashanu, SAN, Sam Ologun Risha, SAN, Solomon Moore, SAN, Abdul Muhammad Rafindadi, SAN. Our lords, our learned friends of the altar bar are also here with us. And they are Omosaya Bola, Esquire, Olarewaju
Onigegewura Akinshola, Esquire. Bolaji Oyin, Esquire. Ms. Huwaila Muhammad Ibrahim. Thank you very much, madam. We're all here for the fourth respondent.
Call number 4.
Petition number CA/PEPC/04/2023 between Allied People's Movement petitioner and Independent National Electoral Commission, All Progressives Congress, Tinubu Bola Ahmed, Kashim Shettima, Kabir Masari.
May it please my lords, Mrs. May Abamuche Umbu, INEC National Commissioner, Chair Legal Services, the first respondent.
Petitioner is absent.
Nice. First respondent is represented, my lord.
My lord, my name is Dr. Abdullah Umar Ganduje, National Chairman, APC, for the first respondent, a second respondent.
My lords, my name is Kashim Shettima. I'm the third respondent. My lords, I'm the fourth respondent. My name is Kashim Shettima.
My lords, the second respondent is represented, the third respondent is absent, the fourth respondent is present in court, and the fifth respondent is absent.
Yes, appearance.
With respect, my lords, my name is Andrew Malgu. My lord, I appear for the petitioner, and my learned friend of the outer bar, J.O. Olotu, appears with me.
Well, with all this translation, please, after this, you submit a clean copy.
Yes, my lord, we had to do some changes in court here, and it is too late for us like this.
Okay.
Both to apply, my lord.
Yes.
May it please my lords, I am Sir Stephen Adehi. I appear with my learned friends of the inner bar, P.M. Inua, SAN, Al-Hassan A. Umar, SAN, Suleiman Olawale Ibrahim, SAN, and our friends of the outer bar, of the inner outer bar, Nasara H. Auta, Esquire, Aminu Sadauki, Esquire, M.A. Atta, Esquire, Susan Imoesi, Esquire, Jamiu Agoro, Esquire, and Martins F. Epa, Esquire. We all appear for the first respondent.
Yes.
Very grateful, my lords.
Second respondent.
Please, your lordships. I'm Chief Dr. Charles Uwensi Edosawa. I make a humble appearance for the second respondent. My learned friends, Chief Afalabi Fashanu, SAN, Sam Ologunrisha, Esquire, SAN, Solomon Umar, Esquire, SAN, Abu Muhammad Rafindadi, SAN, Omosaya Popola, Esquire, SAN. Sorry, my lord, it's my prayer for you, my lord. My prayer for you.
Yes, that's what I think.
Yes, Olayewaju Akinshola, Esquire. Bolaji Oyun, Esquire. And Miss Huwaila Muhammad Ibrahim. We're all here, sirs, for the second respondent. Thank you, sir.
Yes. Third and fourth.
With profound humility to my noble lords, my name is A. Malik. My humble appearance, my lords, is for the third and fourth respondents. My learned brothers of the inner bar, Babatunde Ogala, SAN, Dr. Remi Olatubura, SAN, and Mutalubi Ojo Adebayo, SAN, all appear with me. Together we have our colleagues appearing with us, namely Emmanuel Esquire, Yinka Ajeni Fuja, Esquire, Akintola Makinde, Esquire, Julius Ishola, Esquire, Taiwo Lakanu, Esquire, and if it pleases my noble lords, may I respectfully add one last name.
I can only record what is on the list.
Sorry, my lord.
I can only record what is on the list.
Most grateful, my lord. My lord, our prayers for the third and fourth respondents. Thank you, my lord. Most respectfully, my lord.
Yes.
My name is Gabriel M. Ishon.
Why didn't you submit your own? Oh, it's here.
Submitted the list.
Yes.
My learned friends who appear with me are Ofure Rosella Iyere, Blessing.
Is it on that name? Is it on the list?
Yes, my lord, it's number 6 on our list.
Mention one long name.
O.R. Iyere, my lord. Number 7, BT Orabere, Esquire. Last but not the least, number 8, Edward Ajaba, Esquire. My Lord, collectively, we respectfully appeal for the 5th respondent.
Roll number 5.
Petition number CA/PEPC/05/2023 between Abubakar Atiku, People's Democratic Party for the petitioners, and Independent National Electoral Commission (INEC), Tinubu Bola Ahmed, and All Progressives Congress (APC).
Yes.
My Lord, my names are Umar Ilya Yamagun, Acting National Chairman, PDP, for the second petition.
May it please my lords, this is May Agbamuche Umbu, INEC National Commissioner, Chair Legal Services, for the first respondent.
Dr. Abdullahi Umar Ganduje, National Chairman, APC, third respondent.
One petitioner is represented before the court, as well as the first and third respondent, my lords. Other parties are absent.
With profound respect to my noble lords, I am Chief Chris Uche. I appear for the petitioners, and with me are my learned brothers Silk, namely Eyitayo Tegede SN,
Yes.
Professor Mike Ozekome SN, Nella Andem Ewa Rabana SN. And my lords, permit me with respect to replace absent number 5 with my brother Silk Joe Abraham SN. Then number 6, Professor Maxwell M. Gidado SN.
7. Chief Godi Uche, SN. 8. A.K. Ajibade, SN. And with us, my lords, our learned friends, Silas Joseph Ono Esquire, and Jude A. Daniel Esquire. Together, my lords, we appear for the petitioners. We are grateful, says.
May it please my lords, I am Sir Stephen Adehi. I appear with my learned friends, Senior Counsel, T.M. Ilua, SAN, Al-Hassan A. Umar, SAN, Suleiman Olawale Ibrahim, SAN, and my appearing with us are our learned colleagues, Nasara H. Auta, Esquire, Aminu Sadauki, Esquire, M.A. Atta, Esquire, Susan A. Imoisi, Esquire, Jamiu Aguru, Esquire, and Martins F. Ekpa, Esquire. We appear for the first respondent.
Thank you.
May it please, my lords.
Thank you.
With profound humility to our noble lords, my name is A. Malik. I appear, my lord, for the second respondent. My learned brothers of the Silk, Babatunde Ogala, SAN, Dr. Remi Olatubura, SAN, and Mutalubi Ojo Adebayo, SAN, all appear with me. And we have our other colleagues, Emmanuel Uwadoka, Esquire, Yinka Ajeni Fuja, Esquire, Akintola Makinde, Esquire, Julius Shola, Esquire, and lastly but not the least, Taiwo Lakane, Esquire. Together, my lord, we appear for the second respondent. Go for me, lord.
My lords, for the third respondent, I am Charles Uwensi Edosawa. Yes. My lords, my learned friends, Chief Adeni Akintola, SAN, Chief Afolabi Fashanu, SAN, Sam Ologorisha, Esquire, SAN, Solomon Umar, Esquire, SAN, Abdul Muhammad Rafin Dadi, Esquire, SAN, and my learned friends of the Altibat, Mr. Omose Popola, Mr. Olarewaju Akinshola, Mr. Bolaji Oyun, and Ms. Buwaila Muhammad Ibrahim. They are all with me, sirs, for the third respondent. Most grateful, sirs.
Well, I'll deliver the judgment, but you know that we all know the rules concerning consolidated matters. Each of the petitions or consolidated will maintain their individual identity, so we shall treat them as such. We shall begin with petition number 4. Well, we all remember that during the hearing session, several motions were filed. So we shall begin with the consideration of this application before we proceed to the main petition. So in this petition, that's petition number 3 and number 4, sorry, the petitioner herein, Allied People's Movement, participated in the presidential election conducted by the first respondent on the 26th of February 2023 by sponsoring a candidate, that's J. Princess Chichi, agreed by the declaration and return at the election, has validated its petition filed on the 20th day of March 2023, read this court at paragraph 31 of the petition to grant it the following reliefs. 1. That it may be determined that A. The third respondent was not qualified to contest as the presidential candidate of the second respondent as at 25th day of February 2023 when the presidential election was conducted by the first respondent in the Federal Republic of Nigeria, having violated the provisions of Section 142 sub 1 of the Constitution of the Federal Republic of Nigeria 1999 as amended. B. A declaration that the return of the third respondent by the first respondent as the president-elect of the Federal Republic of Nigeria is null, void, and of no legal effect whatsoever. The third respondent having violated the provisions of Section 142 sub 1 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the fourth respondent having violated the provisions of Section 35 of the Electoral Act 2022. C. The fourth respondent was not qualified to contest as the vice presidential candidate of the second respondent as at 26 February 2023 when the presidential election was conducted by the first respondent in the Federal Republic of Nigeria, having violated the provisions of Section 35 of the Electoral Act 2022. D. The declaration of return of third respondent by the first respondent on 1st March 2023 as the president-elect of the Federal Republic of Nigeria is invalid by reason of non-compliance with the provisions of the Constitution of the Federal Republic of Nigeria 1999 and the Electoral Act 2022. A declaration that having regard to the joint ticket principle enshrined in Section 142(1) of the Constitution of the Federal Republic of Nigeria 1999, the withdrawal of the first respondent as the vice presidential candidate of the second respondent by operation of law amounted to automatic withdrawal and invalidation of the candidature of the third respondent as the presidential candidate of the second respondent for the presidential election conducted by the first respondent on the 26th day of February 2023. A declaration that arising from the invalidity of the third respondent nomination, the first respondent ought not to have included the name or the abbreviation of the name or the logo of the second respondent in the ballot papers and other election materials used by the first respondent for the conduct of presidential election held on 26th day of February 2023. The fourth respondent was not qualified to contest as the vice presidential candidate of the second respondent as at 26th February 2023 when the presidential election was conducted by the first respondent in the Federal Republic of Nigeria, having violated the provisions of Section 35 of the Electoral Act 2022. An order nullifying and voiding all the votes scored by the third respondent in the presidential election conducted by the first respondent on 26 February 2023 in view of his non-qualification as a candidate of the second respondent. Upon the ground of prayer 4 above, an order nullifying and/or setting aside the term of declaration of the respondent as winner of the election conducted by the first respondent for the office of the President of the Federal Republic of Nigeria on the 26th day of February 2023, then having been made in violation of the provisions of Section 142(1) of the Constitution of the Federal Republic of Nigeria, 1999, and Section 35 of the Electoral Act 2022. And finally, upon the ground of prayers 5 and 6 above, and in the absence of the third respondent's participation in the presidential election held on 26 February 2023, pursuant to Section 136 of 2 of the Electoral Act, an order declaring the candidate with the next highest number of votes as the winner of the election. The grounds of the petition as set out in paragraph 15 of the petition is as follows. The petitioner states that the ground upon which this petition is presented is that the third respondent was at the time of the election not qualified to contest the election. The respondents were duly served the petition and also responded by filing their replies. The first respondent reply to the petition was filed on 9th of April 2023. The second respondent reply to the petition was also filed on 9th of April 2023, while that of the third and fourth respondents was filed on 13th of April 2023. The fifth respondent also filed replies to the petition on the 16th of April 2023. The petitioner then filed replies of the respondents to the petition. The respondent filed a number of motions, all of which challenge the contents of the petition. These motions were duly heard during the hearing session and ruling reserved. The first motion was filed by the first respondent. Applicant here in this motion was filed on the 6th of May, wherein he sought the following reliefs. 1. An order striking out paragraphs 2, 3, 4, 5, 6, 7, 13, 14, and 16 of the petition reply filed on 20th day of April 2023 in response to the first respondent's reply. 2. An order striking out paragraphs 8, 9, 10, 11, and 12 of the petition reply filed on 20th of April 2023 in response to the first respondent's reply. And for such further orders as the Honorable Tribunal shall deem fit to make in the circumstance. We were urged to note that the grounds for the petition or for the application are as follows. They have been reproduced in the ruling, and if not, read them out. So the motion is supported by an affidavit of 4 paragraphs and a written address. The petitioner respondent then responded by filing counter affidavit of 7 paragraphs on 13th of May 2023. Then was accompanied by written address in opposition to the application. The arguments of counsel in respect of that application have been considered here in the ruling. A similar application was also filed by the second respondent on the 8th of May 2023, wherein the second respondent prayed this court to grant the following reliefs. 1. An order of the Honorable Tribunal granting leave to the second respondent file and argue this application before or outside the hearing session in this petition. It will be noted that this court is sitting as the Court of Appeal, not as a tribunal. So, an order of this Honorable Court striking out paragraphs 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 5, paragraph 18, 19, 20, 21, 22, 23, and 24 of Part D of the petitioner reply and or the entire petition reply to the second respondent reply to the petition for being an unnecessary repetition and or introduction of new facts unrelated to the second respondent reply to the petition. 3. An order of the Honorable Court striking out in whole or part thereof of the witness statement on oath filed together with the petition reply to the petition for being irregular and in flagrant non-compliance with the relevant provisions of the case schedule to the Electoral Act 2022. The grounds for that application have also been summarized in this document. Same thing with the submission for counsel. The third and fourth respondents also filed a motion on the 13th of May 2023, seeking the following reliefs. 1. An order striking up the entire reply filed by the petitioner on 20th April 2023, together with the accompanying witness statements on oath, list of witnesses to be relied on, and the list of additional documents. 2. Further, or in the alternative to prayer 1 above, an order striking out paragraphs 1, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, up to 21, of the petition reply under the heading Petition Reply to the third respondent's reply to the motion, filed on 20th April 2023, to the applicant's reply to the petition, and for such further orders as this honorable court may feel to make in the circumstances. The grounds have also been referred to in this ruling. We have also considered the submissions of counsel. Now, it is apparent that the first respondent's motion filed on the 6th of May 2023, the second respondent motion filed on the 8th of April 2023, and the third and fourth respondent motion filed on 13th May 2023 are all aimed at having certain paragraphs of the petition replies to the respective replies of the respondent's replies to the petition stuck up. The common ground in all the applications is that the averments in the petitioner's reply have introduced new facts, new issues, facts, and or grounds to the petition. Furthermore, some of them hash or repetition of the averments in the those averments in the petition reply present paragraph 16, subparagraph 1A and B of the first schedule to the Electoral Act 2022. The said paragraph to the Electoral Act stipulates that, I quote, if a person in his reply to the election petition raises new issues or facts in defense of his case, which the petition has not dealt with, the petitioner shall be entitled to file in the registry within 5 days from the receipt of the respondent's reply, a petitioner reply in answer to the new issues or fact, so that A, the petitioner shall not at this stage be entitled to bring in new facts, grounds, or prayers tending to amend or add to the contents of the petition filed by him, and B, the petitioner reply does not run counter to the provisions of paragraph 14.1. In my view, the provisions of paragraph 16.1 of the first schedule to the Electoral Act 2023 are clear, unequivocal, and unambiguous. It does not, therefore, require any technical rule of interpretation to understand or to be understood. From a holistic reading of that provision, it will be seen that it is meant to explain the purpose of a petitioner's reply to the respondent's reply. Its purpose is to raise answers to the defense or any fact which must be specifically pleaded and which have the effect of destroying the respondent's defense or make it not maintainable. The bottom line is that a petitioner is permitted by the first schedule to the Electoral Act 2022 to file a reply while the respondent to the petition has in his reply raised new issues of fact in the defense, which fact the petitioner has not dealt with in the petition. However, in doing so, the petitioner reply shall not introduce new facts, grounds, or prayers tending to amend or add to the contents of the petition. I've cited the case of APC and PEPC citations applied. It is therefore clear that paragraph 16.1 of the first schedule to the Electoral Act does not permit a petitioner in his reply to introduce or bring in any new issue or fact which ought to have been raised in the petition itself. In other words, a petitioner cannot, in the guise of a reply to a respondent's reply, introduce a new issue or fact which was never raised in his petition nor raised by the respondent. To do that will amount to amending or adding to the petition and also taking the respondent by surprise, because at that stage the respondent will not be in a position to react to such new issue or fact. It will therefore breach the respondent's fundamental right to fair hearing. Therefore, the petitioner is not permitted to repair his amendments in the petition in such a way that it will amount to an amendment or restructuring or a reconstruction of the petition. See the case of Dingedi and Wamako citations supplied. With the state of the law as stated above at the back of my mind, I have endeavored to scrutinize the pleadings in the respondent's respective replies to the petition, vis-a-vis the specific paragraphs of the petition replies complaint of. I'll start with the first respondent complaint. The first respondent complaint is against paragraph 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, and 15 of petitioner reply. I have carefully studied those paragraphs of petitioner reply. It is my view that paragraphs 1, 6, 7, 8, 12, and 14 of petitioner reply to the first respondent reply are competent, as they are proper replies to the first respondent's reply. However, paragraphs 2, 3, 4, 5, 9, 10, 11, 13, and 15 of the said petitioner reply are not competent, as they are either rehashed or facts pleaded in the petition, or they introduce and or add new facts to the petition. Being incompetent, they are hereby struck out. The complaint of the second respondent is against paragraph 1, 2, 3, 4, 5, 6, 7, 9, 10, 11, 12, 13, 14, 15, 16, 17, sub 1, 2, 3, and 4. 4 and 5, 18, 19, 20, 21, 23, 24, and 25, part B of the petition reply to the second respondent's reply to the petition. I have carefully considered those paragraphs in the light of paragraph 16(1)(a) and (b) of the first schedule to the Electoral Act 2022. It is settled law that where a respondent raises in his reply to the petition fresh or new issues, it will be necessary for the petitioner to file a reply to the respondent's reply to the petition. At that stage, the petitioner may also file further written statements on oath of witnesses he may wish to call in rebuttal of the new issues raised by the respondent. This is because any failure by the petitioner to reply or answer to those new issues raised by the respondent will be deemed that the petitioner has considered without such fresh or new issues. The cases of Idris and ANPP, Ninjari and Wamako were also cited. That being so, the written statements on oath of witnesses filed along with the petitioner reply to the respondent reply and proof of paragraph struck out accordingly struck out. In my view, paragraphs 1, 2, the paragraph listed in the petitioner reply to second respondent reply to the petition are either rehashed or paragraphs in the petition, or introduced or added new facts to the petition. They are incompetent and accordingly struck out. I am also of the view that paragraphs 1, 3, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 20 of the petition reply to third and fourth respondent reply to the petition the hash of the vermin in the petition. They are, in my view, incompetent and accordingly struck out. This other motion filed by the first respondent on the 7th of May 2023, seeking the following relief. 1. An order of this Honorable Court striking out the petition for being incompetent and an abuse of court process. The grounds of filing the motion have been produced. The motion is supported by 6 paragraphs affidavits because by 1, Chief Nwadike, the litigation secretary in the law firm of Dikko and Mahmoud, solicitor to the first respondent applicant. It is also accompanied by a written address filed in support of the motion. In response, the petitioner filed a counter affidavit on the 14th of May 2023, consisting of 7 paragraphs, deposited by 1 Carlo Kenneth Okorie, litigation secretary in the law firm of Mrs. O.M. Atoyo B.S.N. and Partners. A written address was also filed along with the counter affidavit. I considered the arguments of counsel on this motion. The third and fourth respondents also filed a similar motion on 12th of May 2023. Therein, the third and fourth respondent prayed for an order of this Honorable Court striking out and or dismissing this petition for being incompetent, fundamentally defective, and vesting no jurisdiction on this Honorable Court to adjudicate thereon. The grounds for the petition have been listed. On this motion, several grounds were raised. Now it is apparent that the sole ground of this petition is centered on the qualification of the second respondent. The issue of qualification or disqualification of a candidate to contest an election for the office of President of Nigeria is a constitutional one. That is why it is stipulated in section 134, subsection 1A of the Electoral Act 2022 that election question on any of the following grounds. A person whose election is questioned was, at the time of the election, not qualified to contest the election. The qualifications and or disqualifications of the candidate to contest an election for the office of president are stipulated in section 137 of the Constitution of the Federal Republic of Nigeria as amended. While the qualifications are inserted in section 131, the disqualifications are ingrained in section 137, subsection 1AJ of the Constitution. The issue of qualification of the candidate to contest an election could be a ground in an election petition, though it may also ground a pre-election matter, where such issue of qualification or disqualification of candidate arises from the primary election of the party by virtue of section 285, subsection 14 of the Constitution. Where the issue of qualification or disqualification arises before the election, it is an election, a pre-election matter, and an action on that issue must be instituted pursuant to section 285, subsection 11 and 14 of the Constitution. It should be noted that upon perusal of the pleadings and in the petition, the issue of disqualification of the first respondent rests solely on the issue of the alleged invalid nomination of his running mate with the third respondent. The issue of invalid nomination is captured by paragraphs 18, 19, 20, and 21 of the petition. For proper understanding of the facts pleaded, those paragraphs have been introduced. The second arm of that issue is captured in paragraphs 22, 23, 24, and 25, and 26 of the petition. Considering the facts pleaded above, it is clear that the claim of disqualification or non-qualification non-qualification of the third respondent is centered solely on the invalid or double nomination of the fourth respondent. However, it is the settled law that the issue of nomination of a candidate at an election is a pre-election matter. Therefore, the issue of qualification or disqualification can only be ventilated on the grounds enumerated in Section 31 or 137 of the Constitution. That is why Section 84, subsection 3 of the Electoral Act 2022 stipulates that a political party shall not impose nomination qualification or disqualification criteria, measures, or conditions on any aspirant or candidate for any election in its constitution, guidelines, or rules for nomination of candidates for election, except as prescribed under Section 65, 66, 106, 107, 131, 137, 177, and 185 of the Constitution. 187. It therefore means that The conditions of qualification or disqualification are prescribed by, under Section 131 and 137 in case of person contesting for office of president. That means that why it is alleged in an election petition that a person is or was not qualified to contest election to the office of President of Nigeria, as stipulated in Section 134, subsection 1A of the Electoral Act 2020. It is Sections 131 and 137 of the Constitution of Nigeria that are applicable. See the cases of PDP and ANEC, Kaki and PDP, Ucha and Unwe, and Captain Idris, Chalawada and others, versus Yahya Bello and others, all citations supplied. That's why election and result declared such election cannot be questioned on grounds of qualification under Section 131 and 137 of the Constitution in the case of a presidential election. This postulation is supported by Section 134, subsection 3 of the Electoral Act, where it is stipulated that with respect to subsection 1A, a person is deemed to be qualified for an elective office, and his election shall not be questioned on grounds of qualification if, with respect to the particular election in question, he meets the applicable requirements of Section 65, 106, 137, not applicable in brief of Section 66, 107, 137, or 182 of the Constitution. As stated earlier, the applicable provisions are Section 131 and 137 of the Constitution. It is clear from the plenitude of the pleadings in this petition that the facts grounding the petition's claim of disqualification or non-qualification of the third and fourth respondent is seen to double and invalid nomination of the first respondent. I had pointed out earlier in the course of this ruling that the issue of qualification or disqualification of a candidate at an election is strictly a requirement of the Constitution. That is held case of Al Hassan and another versus Ishaku and others, citations supplied a court by virtue of the provisions of Section 138 of 1A of the Electoral Act. The tribunal's power to decide whether a person is qualified to contest an election is restricted to establishing the requirements of Section 177 and 182 of the Constitution against the adverse party. An election tribunal has no jurisdiction to inquire into the families of a political party, close of court. It is apparent, therefore, that issues of nomination or sponsorship of candidates by political parties come under pre-election matters and should be disputed and determined before the conduct of the election. P. Shinkafi and others versus Yari and others, Ella and others versus Abu. That being so, a ground of election petition questioning the election of a person duly qualified to contest such election as required by the Constitution cannot be sustained, where it is predicated on nomination or sponsorship of such candidate. Therefore, a petitioner who relies on non-qualification of his opponent to nullify the election must bring the facts of such non-qualification within the ambit of Section 131 and 137 of the 1999 Constitution. I have noted that the petitioner respondent sought to tie his complaint of non-qualification to Section 141 of the 1999 Constitution. That provision stipulates as follows. I quote, in any election to which the foregoing provisions of this part of this chapter relate, a candidate for an election to the office of president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party or he is running for the office of president, who is to occupy the office of vice president, and that candidate shall be deemed to have been duly elected to the office of vice president if the candidate for election to the office of president is duly elected as president in accordance with the provisions of aforesaid. I am of the view that the above cited provision of the Constitution does not create additional obligations for a candidate contesting for the office of president of Nigeria. Furthermore, Section 142 of the 1919 Constitution, read along with Section 141 of the said Constitution, create the office of president and vice president. Section 142(1) is a specific provision donating power to the president to nominate a person as his associate to occupy the office of the president. That's why subsection 2 of Section 142 mandates that the requirements of qualification and disqualification attaching to the occupier of seat of president also applies to the holder of the office of vice president. It is therefore my view that Section 142, subsection 1 of the Constitution does not introduce the issue of nomination or sponsorship for vice president so as to enlarge the scope of qualifications or disqualifications applicable to the seat of president. There cannot therefore be a disqualifying factor of a candidate for the office of president outside those specified in Section 131 and 137 of the Constitution. It can safely be said that those provisions have sufficiently and conclusively covered the field until there is an amendment to the Constitution. In the case of the IG, ADIA, and AD federations, also PDP and ANIC Super. As a follow-up to my findings above, I hold the firm view that the issue of nomination of sponsor of the respondent being a pre-election matter ought to have been ventilated by the petitioner before the Federal High Court, as this court has no jurisdiction to delve into the matter. Even if this court has such jurisdiction, because of action being a pre-election matter, that's bad. Section 5 of 9 of the Constitution of the Federal Republic of Nigeria 1999 was amended. Having found as above, it is my view that the two motions filed by the first respondent and third and fourth respondent on 7 May 2023 and 12 May 2023 respectively have no merit. Accordingly, I find that the petition is have merit. Accordingly, I find that the petition is liable to be struck out for being incompetent. By a motion on notice filed on the 8th of May 2023, the applicant sought the following relief. An order of this Honorable Tribunal granting leave to the second respondent applicant to bring and argue this application before, or outside, or during the pre-hearing session. 2. An order of this Honorable Tribunal striking up grounds 1 and 2 contained in paragraph 16 of the petition for being incompetent. 3. An order of the Honorable Tribunal striking out paragraph 17, 18, 19, 20 to 29 of the petition, which are predicated on the incompetent grounds 1 and 2 in paragraph 16 of the petition for being an abuse of court process. And 4. An order of this tribunal striking up reliefs 1 to 7 of the petition for being incongruous, illogical, and ungrantable. And 5. An order of the Honorable Tribunal dismissing or otherwise striking out the petition for one of the reasons and on the ground that the petition does not disclose any reasonable course of action. Here's the grounds stated here in. I've considered the arguments of counsel which I've summarized in the ruling. It will be seen that is on several grounds. The first is that the grounds of the petition are incompetent. This is premised on the erroneous argument of the second respondent of applicant that the grounds for the petition are as stated in paragraphs 16 of the petition. The careful perusal of the petition will disclose that there is only one ground for the petition and is stated in paragraph 15 of the petition as follows: that your petitioner states that the ground upon which this petition is presented is that the third respondent was at the time of the election not qualified to contest the election. The averments in paragraph 16 as unequivocal caption deal with the facts of the petition. This ground for the objection to the contents of this petition therefore lacks substance and is accordingly discountenanced. The second ground for the objection is that the petition is an abuse of court process. It is premised on the fact that the had earlier instituted an action before the Federal High Court in suit number FHC/ABJ/CS for 1215/2022 between Allied People's Movement and INEC on the same subject matter as in this petition against the first, second, third, and fourth respondents in this petition and others. It was, however, disposed in paragraph 3M of the counter affidavit filed by the petitioner in opposition to this application that the matter was not determined on the merit by the trial court, who referred the matter to the court appeal for interpretation. That in any case, the matter had since lapsed in 180 days for determination by law, being a pre-election matter. It is tried law that abuse of court or judicial process simply means the use of a court process mala fide or in bad faith to the annoyance of the opponent. One variety of it is the institution of multifarious actions between the same parties with regard to the same subject matter and same issue in the same or another court. A quick look at the originating summons in suit number FHC ABJCS 1275-2022, which was in the Federal High Court, Abuja, on 27 July 2022. Being a pre-election matter, it ought to have been determined within 180 days, as required by Section 285, subsection 10 of the 1999 Constitution. It therefore means that it lapsed by January 2023, about a month the election in question was conducted. This petition having been instituted on the 20th of March 2023, when suit number FHC was no more alive, does not qualify as an abuse of court process. This ground for this objection is also from tenants. On whether this petition is caught by the doctrine of estoppel, it was argued that the issues raised in this petition have been firmly resolved by the Court of Appeal in Appeal number CS from ABJS from CS from 08 for 2022. Issue estoppel arises when the issue has been decided upon to finality by a court of competent jurisdiction. In other words, once an issue has been raised and distinctly determined between the parties, another party can be allowed to fight that issue all over again. The same issue cannot be raised by other parties again in the same or subsequent proceedings, except in special circumstances. For issue estoppel to apply, the following conditions must be satisfied. A, the same question must have been decided in both proceedings. B, the decision which creates the estoppel must be final, and the party to the judicial decision or their previous to the proceedings to which the estoppel is raised must be the same. To determine whether the above three elements exist, the court will closely examine the reasons for the judgment and other relevant facts that were actually in issue in the proceeding. See the cases of Oyekola and others versus Amodu, OSPM Limited versus Nigel Company Nigeria Limited, and Dasuki Retired versus Federal Power Nigeria that Stephen supplied. I have studied the case sought to be relied on as estoppel in this case. It is apparent that the parties in that case are not the same as in the instant petition. The issues, though the same, were not resolved to finality in the previous case. The action was struck out on ground of lack of local standard by the lower court, which this court affirmed on appeal. Thus, the objection on that ground is also discontinued. On whether the question is started back, I had held in the earlier motion filed by the first respondent on 7th May 2023 and third and fourth respondent's motion filed on 12th May 2023, which were taken together. This petition, which is premised on the nomination of sponsorship of the fourth respondent, is a matter before the Federal High Court within 14 days from the date of occurrence of the event or action complaint of. That not having been done, the course of action in this position stands barred by virtue of Section 2859 of the 1992 Constitution of the Federal Republic of Nigeria as amended. On the issue of local standing, I have also held in the 5.5.3 and 12.5.3 that issues of nomination or sponsorship of candidates by political parties for an election come under pre-election matters. It is settled that the issue of nomination of candidates by substitution is purely a pre-election matter. The only person with the local standing to challenge the nomination is an aspirant who participated in the process of such nomination. In other words, apart from an aspirant who took part in the primary election, no other person is authorized to challenge such nomination by a political party to an election. That process of challenging the nomination is sanctioned by Section 84, Subsection 14 of the Electoral Act and 285, Section 14 of the Constitution. Shinkafi and another versus Abdul Aziz Ayari and Al Hassan another and Ishaku. It therefore follows that the course of action in this petition, which is rooted in the nomination or sponsor of the fourth respondent, is a pre-election matter. Being a pre-election matter, the petitioner herein has no local standing to challenge or question such nomination or sponsorship of the fourth respondent by the second respondent. Thus, in People's Democratic Party (PDP) and Independent National Electoral Commission and others of the Supreme Court, delivered on 26th day of May 2022 in SC.CV.501.2022. I had the matter has been reported, but I have not been able to avail myself of the report. Held at the Supreme Court, held at page 71 at follows, the third one, lines 1 to 16 thereof as follows. Court, the provision does not make the filing of pre-election matters by political parties an all-comers affair. It is not the purpose of the provision that the floodgate of pre-election litigation be open to political parties who will hide under it to challenge the actions or inactions of rival political parties under the guise of challenging the decisions or activities of INEC. The application of Section 285 Section no political party can of another political party, no matter how pained or disgruntled a political party is with the way and manner another political party is conducting or has conducted its affairs concerning its nomination of its candidates for any position. It must keep mum and remain an onlooker, for it lacks the local standing to challenge such nomination in court. Close of court. It is clear, therefore, that a political party, such as the petition is herein, only has the local standing to file a pre-election matter when the situation affects it or its candidate by virtue of Section 285, Section 14C of the 1999 Constitution. That being so, as in the instant petition, where the grounds of the petition is rooted on the nomination or sponsorship of the candidate of another political party, this petitioner will have no local standing to institute the action, be it in the Federal High Court or an election tribunal. For that reason, it is my view that the course of action in this petition being on the nomination and sponsorship of the third and fourth respondents by the second respondent applicant, petition is incompetent for lack of local standing on the petition to institute the action. It is also liable to be struck out for being incompetent. The second respondent applicant also contended that the petition is not properly constituted as the candidate sponsored by the petitioner has not been joined as co-petitioner in the petition. The short answer to that is that Section 133, Subsection 1B of the Electoral Act 2022 entitles a petition as a political party to institute an election petition. The applicant has not referred us to any provision of the Electoral Act or any authority that mandates the political party to file an election petition only when its candidate has been joined as a co-petitioner. It is true that it is proper for the candidate of the party to be so joined, but there is no law that compels the political party to join its candidates in the petition. After all, the purpose of such joinder is so that the candidate can be bound by any judgment or order of the court or tribunal, but any non-joinder will not invalidate the petition. This is particularly so when Section 133, Subsection 1 of the Electoral Act stipulates as follows. An election petition may be presented by one or more of the following persons: A, a candidate in an election, or B, a political party which participated in the election. By the use of the disjunctive word "or," it means that an election petition may be filed by the candidate alone, or the political party alone, or both of them. The objection on this ground is also discontinued. By another motion filed on the 16th of May 2023, the fifth respondent, thus Kabir Masari, prayed this court to grant him the following reliefs 1. An court petition in its entirety for one of the division. 2. An order striking out the name of the fifth respondent applicant from this petition for non-disclosure of any reasonable course of action against him. And 5 other orders are this honorable court may deem fit to make in the circumstances. The grounds for the application have been stated. Have also considered the submissions of counsel. Section 133 of the Electoral Act defines persons who are necessary parties in an election petition. Generally, necessary respondents in an election petition are the persons whose election or return is complained of and the electoral body that conducted the election. See Section 133, subsection 2 and 3 of the Electoral Act 2022. Those are what are termed statutory respondents. It should be remembered that election petitions are sui generis and its procedure is strictly regulated by statute. That's why a person does not fall category of respondent. They are not necessary parties in an election petition. See the cases of Akbere and Mimra, Buhari and Yusuf, APC and PDP. That's in Waziri versus Gaidam. The Supreme Court held a court. From the above, I have no difficulty in going along with the submissions of the respective counsel for the respondent. That Section 137, sub 2 and 3 of the Electoral 2020 has no room for the joinder of the fifth respondent who neither won the election nor performed any role as electoral officer or agent of the third respondent in the election petition, challenging the result of such an election. And even no relief was claimed against the said fifth respondent, and indeed, he had nothing to gain in the close of court. Indeed, a holistic reading of the facts of this petition does not disclose any complaint against the fifth respondent. The only fact that relates to the fifth respondent relevant to the petition is the act of withdrawal of his candidacy as the running mate of the third respondent. That is an act that occurred within the pre-election period, therefore cannot amount to any act done by the fifth respondent at the election. It cannot therefore ground any complaint by the petitioner against the fifth respondent in an election petition. It may be relevant in a pre-election matter, but not in an election petition. It is therefore my finding that there is no any claim on the fifth respondent. In other words, the relief sought in the petition will not in any way affect the fifth respondent, as he did not participate in the petition either as a candidate or agent of the second respondent, and no declaration was made in his favor by the fifth respondent. In that respect, I hold that the objection of the fifth respondent on this ground has merit. Accordingly, I order that the name of the fifth respondent be struck out of this petition. These are the rulings in respect of the petition number 4. I will now go to the main petition itself. So, after the pre-hearing session, hearing on the petition opened and closed on the 21st of June 2023, the petitioner called one witness and closed his case. None of the respondents called any witness, but tendered some documents from the bar, and the petition was adjourned for adoption of written addresses. Parties then filed and served written addresses as directed by this court, and same were adopted on the 14th of July 2023. The matter was then adjourned for judgment. The first respondent's written address, the 3rd June 2023, therein 4 issues were raised for determination as follows. 1. Whether considering the facts of the petition and evidence laid thereon, the petitioner has the lawful standing to question the nomination of the first respondent as a ground of challenging the qualification and term of the third respondent as the winner of the presidential election of 26 February 2023. 2. Whether having regard to the facts pleaded and evidence laid thereon, vis-a-vis the provisions of Section 134, subsection 3 of the Electoral Act 2022, can the issue of validity of the nomination of the first respondent as the vice president candidate of second respondent be validly raised as a ground before this honorable court to question or challenge the qualification and return of the third respondent as the winner of the presidential election of 25th February 2023. Number 3, if the answer to note 2 is in the affirmative, whether having regard to the facts pleaded, the nomination of the first respondent as the vice president candidate of the second respondent is void, as to render the third respondent not qualified to contest the presidential election of 25th February 2023. 4, whether considering the relief sought as per the petition accrues no utilitarian benefit to the petitioner, this petition not an abuse of court process. Well, to save time, all the other respondents filed briefs and raised issues. These issues have been introduced in this judgment, including the issues raised by the petitioner. Now, it is apparent from the averments in the petition, the oral and documentary evidence, and the submissions of counsel that this petition is grounded on the disqualification of the third respondent to have contested the presidential election of 26 February 2023. This is evident in paragraph 15 of the petition, wherein the petitioner pleaded that, I had read it earlier. This is further explained as emanating from the non-qualification of the first respondent to have contested the election as the vice president candidate of the second respondent. It is specifically pleaded in paragraph 17 of the petition as follows. Your petitioner states that the first respondent was not qualified to jointly contest with the third respondent for the presidential election held on 26 February 2023, having been purportedly nominated by the second respondent as its candidate for more than one office. The specific reasons for questioning the qualification of the third respondent have been pleaded in paragraphs 16.1 and 2 of the petition as follows. Those paragraphs have been reproduced. If you get the judgment, you will see it there. So a combined reading of paragraphs 15, 16, and 17 of the petition, coupled with the particulars thereof, show clearly that the petition is premised on non-qualification of the first respondent. I find it necessary to state that the grounds for questioning the return at an election are stipulated in section 135, subsection 1 of the Electoral Act. That has been proposed earlier. For the purpose of this petition, it is the ground stipulated in section 134(1)(a). The respondent as president and vice president is questioned on the ground that they are not qualified to have contested the said presidential election. I've considered paragraphs 18, 19, 20, 21, 22, 23, 24, 26, and 28 as relevant for the termination of the petition, which paragraphs have been reproduced in this judgment. The respondent replied to the petition as follows, which have also been reproduced. The second respondent also filed a second respondent reply to the petition and also made their own averments in paragraphs 18, 19, 20, 21, 23, 24, 25, 26, and 25, which have been produced herein. So from the totality of the pleadings in the petition and the replies of the respondent, what appears in the complaint of the petitioner is that the fourth respondent, while still a candidate of the second respondent for Borno's Central Senatorial District, was nominated and did accept to be the vice president candidate of the second respondent, that this act violated the provision of Section 35 of the Electoral Act 2, as it amounted to his double nomination. That in the circumstances, his nomination as an associate of the second respondent for the present election is void. That the result is that the third respondent was disqualified from contesting the election because he did not have a validly nominated running mate at the time of the election. The petitioner relied on Section 131 and 142(1) of the 1999 Constitution for his postulation. Section 131 and 142 sub 1 of the Constitution of Federal Republic of Nigeria, as amended, stipulate as follows. A person shall be qualified for election to the office of president if A, he is a citizen of Nigeria by birth, B, he has attained the age of 40 years, C, he is a member of a political party and is sponsored by that political party, and D, he has been educated as follows. A person shall be qualified for election to the office of president if A, he is a citizen of Nigeria by birth, B, he has attained the age of 40 years, C, he is a member of a political party and is sponsored by that political party, and D, he has been educated up to at least full certificate level or its equivalent. 142(1). In any election to which the foregoing provision of this part of this chapter relate, a candidate for an election to the office of president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party for his running mate for the office of president, who is to occupy the office of vice president, and that candidate shall be deemed to have been duly elected to the office of vice president if the candidate is for election to the office of president who nominated him as such associate is duly elected as president in accordance with the provisions aforesaid. The general principles of interpretation of the Constitution, which is the supreme law of the land, is that mere technical rules of interpretation of statutes are to some extent be avoided in a way as not to defeat the principles of government. Thus, where the words used are clear and unambiguous, a literal interpretation should be applied. In the interpretation, therefore, the provisions of the Constitution are to be accorded holistic interpretation so as to avoid ambiguity and arrive at the true intention of the legislature. The court must limit itself to the words used in the Constitution without resort to any external aid or materials. In the cases of Sani and President Federal Republic of Nigeria, Amadi and Ani, and Agi and PDP and others. Thus, in Wike Ezonwo Nwesom, Honorable Dr. Okuku, Adol, Peterside, and others, the Supreme Court observed that, I quote, the principle of conception of the Constitution to the effect that a Constitution is a living document, not just a statute, providing a framework for the governance of a country, not only for the present, but for generations yet unborn. It was held that in construing the Constitution, undue regard must not be paid to merely technical rules, because in doing so, the objects of the provisions as well as the intention of the framers of the Constitution will be frustrated. Courts have always been encouraged to adopt a broad and liberal spirit in interpreting the provisions of the Constitution while constantly bearing in mind the object which such provisions were made to serve, close of court. That being so, where the Constitution has stipulated the qualifications to be attained by a person contesting or seeking to contest for any elective office created by the Constitution, the courts cannot create or import into the Constitution any other qualifying or disqualifying factor. This has been the position of the Supreme Court and dutifully followed by this court. It has therefore been held that qualification or disqualification of candidates to contest election is exclusively determined within the context or scope of the Constitution, and that nothing can be added to it. In other words, the Constitution, being the ground norm, is superior to any other law, including the Electoral Act. Therefore, where the Constitution has qualified a person or candidate to contest an election, no other law except the Constitution itself can disqualify him. The petitioner in this case has premised his complaint of non-qualification or disqualification of the third and fourth respondents as the president and vice presidential candidates of the second respondent on the issue of invalid nomination of the fourth respondent. The fourth respondent, while still the senatorial candidate of the second respondent for the Borno Central District, allows himself to be nominated as the vice presidential candidate of the second respondent for the same election. Rulings earlier delivered on the motions and preliminary objections, we had ruled that the petition grounded solely on the issue of invalid nomination or improper nomination is not a cognizable ground of disqualification under the Constitution. In other words, the claim in the petition that the third respondent was not qualified to contest the presidential election because he nominated an associate whose nomination was invalid does not flow from any ground of disqualification of a candidate to the office of president as stipulated in section 131 and 137 of the 1999 Constitution. See the cases of Balewa and Muazu and Faleke and Ainik, Tazu versus Ioria. Then in Shinkafi versus Yari, the Supreme Court held that the Supreme Court has listed in section 182, section 182 very exhaustively all the issues that can qualify a person from contesting the office of governor of a state. From the record of this court, the facts have not disclosed any evidence to show that the first respondent was not qualified to contest elections into the office of governor of Zamfara state. It is my view that once a candidate sponsored by his political party has satisfied the provisions set out in section 177 of the Constitution and is not qualified under section 182 subsection 1 thereof, he is qualified to stand election to the office of governor of a state. No other law can qualify him. This authority can apply mutandis to section 131 and 137 of the Electoral Act. It has not been contended by the petitioner that either the third or fourth respondent is trammeled by the provisions of section 131 or 137 of the 1999 Constitution. The complaint of the petitioner rooted on nomination and sponsorship of third and fourth respondent will find accommodation in a pre-election dispute, which the petitioner cannot even pursue, not being a member of the second respondent. This section 84, subsection 14 of the Electoral Act 2022 and 285(14) of the Constitution. While I'm tempted to put an end to this petition at this stage, but realizing that this court is not the final court on the matter, I'm constrained to look at the merit of the petition. As pointed out earlier in the course of this judgment, a complaint of the petitioner in this petition is that the third respondent was at the time of the presidential election held on 25th February 2023 not qualified to contest the election. This is because, according to the petitioner, the fourth respondent was not qualified to run on a joint ticket with him, that is third respondent, as the fourth respondent nomination was invalid for double nomination, which violates section 55 of the Electoral Act 2022. As stated earlier, the petition contended that the fourth respondent was a candidate of the second respondent for the Borno Central District when the third respondent nominated him as his vice presidential candidate on the 14th July 2022. In other words, that at the time the fourth respondent was nominated, he had accepted nomination as the vice presidential candidate of the second respondent, who was still a validly nominated central candidate of the second respondent for Borno Central District. The petitioner then contended that the second respondent had earlier submitted the name of the third respondent together with that of the fifth respondent to ANIC as his presidential and vice presidential candidates for the 25th February 2023 election. However, that before the date of the election, the fifth respondent withdrew his candidature as the running mate of the third respondent on the 24th June 2023, and the name of the fourth respondent was then submitted to ANIC, that first respondent, on the 15th July 2022. That the second respondent did not conduct any fresh primary election for the purpose of picking another running mate for the third respondent after the withdrawal of the fifth respondent. The respondents conceded that the fourth respondent was ab initio the central candidate of second respondent, for Borno Central District. However, that on the 6th July 2022, the fourth respondent via a letter dated the same date notified his political party, that second respondent, of his withdrawal from the central candidature. That upon receipt of the fourth respondent letter, the second respondent immediately notified INEC, and which notification letter was received on the 13th July 2022. That the same letter also notified the first respondent of its intention to conduct a fresh primary election for the replacement of the fourth respondent following his withdrawal as a central candidate. That it was until 14th July 2022 that the fourth respondent was nominated as the third respondent associate for the presidential election of 25th February 2023. The fifth respondent notice of withdrawal as a candidate is in evidence as Exhibit PA2, while the notice of withdrawal and letter of voluntary withdrawal of the fourth respondent are in evidence as Exhibits PA3 and PA4 respectively. It will appear that the petitioner is the view that the fourth respondent was still the central candidate of the second respondent as at the 14th of July 2022, when thus the fourth respondent was nominated as the vice presidential candidate of the second respondent. However, the respondents contended that the issue of alleged double nomination of the fourth respondent has been determined finally by the Supreme Court in People's Democratic Party, PDP versus ANIC, that in the circumstances, the said judgment of the Supreme Court constitute estoppel parem judicata and binding on the parties in this petition. Now, for a judgment to constitute issue estoppel, the conditions are earlier stated in the rulings. So the three elements must be present and coexist for a plea of estoppel parem judicata to apply. In the cases of Ito and Epe and others, Oshoboja versus Amida and others, and Alexandra and others versus Lone Star Drilling Company Limited, all citation supply. It is obvious that the judgment sought to be relied on for the plea of estoppel is that of the Supreme Court, the highest and final court in this country. There is no doubt that the decision was final, and the issue that was determined by the Supreme Court is the same as in the present petition, with whether the fourth respondent breached Section 35 of the Electoral Act by allowing himself to be nominated in more than one constituency. The petitioner has, however, argued that the issue decided by the Supreme Court was merely on the local standing of the PDP to question the nomination of the fourth respondent, the candidate of the APC, a different political party. That may well be so, but it is clear from the judgment, thus Exhibit X1, that the Supreme Court pronounced on the substantive issue of double nomination. So, Joro JSC, who delivered the lead judgment, declined to exercise the powers of the Supreme Court under Section 22 of the Supreme Court Act to pronounce on the merit of the case. The other laws of the Supreme Court proceeded to do so. It is settled law that a contributory or concurrent judgment has equal weight as the lead judgment. It is part of the lead judgment and therefore has the same force and binding effect. The mere fact that a concurring or contributory judgment contains what is not in the lead judgment will not whittle down its binding effect. Thus, in Olu Fegba and others versus Abdurrahim, my Lord Fabi JSC said, quote, the concurrent judgment has equal weight with or as a lead judgment. A concurrent judgment complements, edifies, and adds to the lead judgment when the justice adds its certain fact aspects which the writer of the lead judgment did not remember to deal with. Insofar as the concurrent judgment performs same for all the above functions, it has equal force with or as the lead judgment insofar as the principles of stare decisis are concerned. Now it is apparent that the parties in Exhibit X1, PDP and ANIC and other supra are not the same as in the present petition. The earlier decision, though, involved the first, second and fourth respondents. The present petitioner was not a party in that case. That is why it was argued by the petitioner herein that Exhibit X1 cannot operate as to stop it from litigating the issue of dominant nomination of the fourth respondent. The respondents have responded that the judgment in PDP and Annex Exhibit X1 is a judgment in rem as opposed to judgment in personam. In law, a judgment in personam is a judgment against persons who are parties or previous to the particular suit or proceeding alone. It is referred to as judgment inter partes. It is a judgment binding on the parties to the action alone. A judgment in rem, on the other hand, is a judgment that determines the status of a person or thing as distinct from the particular interest of a party to the litigation. It is referred to as judgment contramundum, binding on the whole world. It is therefore binding not only on the parties to the dispute, but even non-parties. Therefore, once the status of a person or thing has been pronounced upon by a court of competent jurisdiction, no person is permitted to assert the contrary of what that court has decided. See Black's Law Dictionary, 11th edition at page 1008, Demishola versus Bola, Yanati Petrochemical Limited and EFCC, then Ladi Jobi and others versus Oguntayo and others, partition supply. It is no doubt that the judgment matter in PDP and INEC others X1 was in respect of the alleged double nomination of the first respondent as the vice president candidate of the second respondent in the 25th February 2023 presidential election. That is the same issue raised in this petition as grounding the disqualification of the third and fourth respondent in this petition. Pronouncing on this issue in this case, in the contradictory judgment, my Lord Okoro JSC, who presided on the panel of the Supreme Court, held as follows, I quote, "There is no doubt that the fourth respondent was at his stage nominated as a candidate representing Borno Central District, but upon being muted, he would pair with the third respondent as vice presidential candidate of second respondent, All Progressive Congress, APC, in the 26th February 2023 general election. He withdrew his candidature for the Senate before taking up the position of vice presidential candidate. Documents in the record attest to this fact. These are APC 1, APC 2, which were made on the 6th and 10th of July 2022, respectively, laws of court. After considering those documents, His Lordship concluded at page 7 of the contrary judgment that, quote, "It is crystal clear that the two exhibits alluded to above, the fourth respondent did the needful by resigning his position of Senate candidate for Borno Central District since 6 July 2022, before being nominated by the third respondent to run alongside him as vice presidential candidate of All Progressive Congress," close quote. My Lord Okoro went on to, after citing section 31 of the Electoral Act 2022, held at page 8 of his contributory judgment that I quote, "The above provision of the Electoral Act 2022 was duly complied with by the respondent. My well-considered opinion that as at the 6th of July 2022, having withdrawn his nomination and personally served him on the second respondent of the withdrawal of nomination of 6 July 2022, the fourth respondent was no longer a candidate for the Borno Central District elections, and his subsequent nomination as vice presidential candidate of the second respondent for the presidential election was not multiple nomination, as there was no longer a nomination for the fourth respondent since his withdrawal on the 6th of July 2022. I have also cited the elaborate contribution of His Lordship, Ajim JSC. So I have endeavored to quote extensively the dicta of the laws of the Supreme Court in PDP and INEC Supra in order to show that the issue of double or even multiple nomination of the fourth respondent as the central candidate and vice presidential candidate of second respondent in the 25th February 2022 general election has been settled to finality. It is a judgment in rem, therefore binding on the parties to this petition and in fact the entire world, including this court. Being the judgment of the final court of the land, of this land, this Supreme Court, no person is permitted to again raise and litigate on it in any other action or proceeding. It is therefore settled and remains settled that this petition, which questions the qualifications and seeks to disqualify the third and fourth respondents from contesting and occupying the seat of President and Vice President of Nigeria on ground of double or multiple nomination of the first respondent and Vice President candidate of the second respondent on ground of double or multiple nomination of fourth respondent has no substance. I only wish to add that Section 35 of the Electoral Act is targeted at the candidate and not the political party. That is why it uses the terms a candidate and normally allows himself to be nominated by more than one political party or more than one constituency. Thus, to prove that the candidate knowingly allows himself to be so nominated, both the intent and actual acts of nomination, that is, the mens rea and actus reus of the act prohibited, must be proved, the stipulation in the section being a penal provision. In the instant case, neither the intent nor the fact of the first respondent to allow himself to be so nominated was established. That's why His Lordship Ogumi JSC, in his contributory judgment, in Exhibit X1, held as follows, I quote, by Section 31 of the Electoral Act, the first respondent, Shettima, was obliged to submit a notice of withdrawal in writing to his party, which he did, and then his party is to deliver that notice to the Commission not later than 90 days to the election. In view of the above stated position of the law on this issue and the facts of this case, there exists no animus or display of intention by the first respondent to stand as the nominated candidate of the second respondent for the vice presidential position and also the senator representing Borno Central District in the general election of 25 February 2023. There cannot be any other interpretation in the circumstances unless there is clear intention to knowingly stand as a candidate for two elective posts in the same election cycle. Jim JSC also contributed as follows, quote, the manifest intention to relinquish the earlier nomination to pave way for the nomination of another person to replace him as the party's central candidate cannot be overlooked or disregarded. To simply isolate the assumed or purported short-lived coexistence of the two nominations for treatment as multiple nominations without regard to the obvious intention of the first respondent not to be the party's candidate in elections in two constituencies is against the legislative intent of Section 35 of the Electoral Act 2022. The sequence of the occurrence of the events is not what determines the existence of multiple nominations. It is the intention, design, or purpose to hold two or more nominations as candidate for election that shows that the person so nominated knowingly did so. Second respondent did not intend that the first respondent should be its candidate for Borno Central election and its vice presidential candidate for the presidential election. The first respondent did not understand or know that he was so nominated. The word knowingly in Section 35 of the Electoral Act must be interpreted broadly to include all its literal meanings. Barton's Legal Thesaurus, 4th edition by William C. Barton at page 356, is defined to include advisedly, deliberately, designedly, intentionally, learnedly, pointedly, purposefully, with knowledge, etc. It is clear to me, therefore, that from the oral and documentary evidence adduced by the parties on this petition, the intention and fact of knowingly allowing himself to be nominated in more than one constituency as alleged by the petitioner against the first respondent has not been established. In other words, both the mens rea and actus reus of the act prohibited by Section 35 of the Electoral Act 2020 were not established. One other aspect alleged by the petitioner on his claim of invalid nomination of the third and fourth respondent is that the second respondent did not comply with Section 33 of the Electoral Act in the nomination of the first respondent as vice presidential candidate. That after the withdrawal of the fifth respondent, the second respondent should have conducted a fresh primary election within 14 days for the purpose of nominating a new vice presidential candidate. Now, Section 33 of the Electoral Act stipulates that a political party shall not be allowed to change or substitute its candidate whose name has been submitted under Section 29 of this Act, except in the case of death or withdrawal by a candidate, provided that in the case of such withdrawal or death of a candidate, the political party affected shall, within 14 days of the occurrence of the event, hold a fresh primary election to produce and submit a fresh candidate to the Commission for the election concerned. The interpretation of this provision does not, in my view, cause any difficulty as to require the application of any technical rule of construction. Therefore, a literal interpretation will suffice. It therefore means that where a political party has submitted the name of a candidate pursuant to Section 29 of the Electoral Act Supra, it cannot be allowed to substitute or change that candidate except in the event of death or withdrawal of such candidate. By the proviso thereto, the political party affected is enjoined to conduct a fresh primary election for the purpose of producing a new or fresh candidate to submit to the Electoral Commission. The grounds of the petitioner here is that the fifth respondent withdrew his nomination as vice presidential candidate of the second respondent, but the second respondent did not conduct another primary election for the purpose of producing a new vice presidential candidate within the 14 days prescribed by Section 33 of the Electoral Act. It should be remembered that by Section 142, subsection 1 of the 1999 Constitution, a presidential candidate for election to the office of president has the sole discretion, authority, or power of nominating his associate who shall run with him in the election as vice president. The choice or nomination of vice presidential candidate is not the product of any primary election. Therefore, in my view, the requirement to conduct a fresh primary election does not apply to the nomination of a vice presidential candidate. Thus, my Lord of GJC alerted this point in its 1 as follows. The fourth respondent was not required to buy any nomination form. He was the second respondent, APC's candidate at the election into the office of Senator representing Borno Central District. But before the election could hold, he was nominated as the third respondent's associate, who is to occupy the office of vice president. The fourth respondent did not buy a nomination form for the said office, and most importantly, did not contest any primary election in order to emerge as APC's vice president candidate. Close of court. The petitioner in paragraph 28(2) of his petition had averred and also contended in his final address that there was a gap of about 3 weeks between the period the fifth respondent expressed his intention to withdraw and his actual withdrawal or purported nomination, thereby invalidating the nomination of third respondent because the candidature of the third respondent had lapsed and was no longer in a position to constitutionally terminate a running mate. This contention of the petition is, however, misconceived. There is nothing in the Constitution which robs a presidential candidate of his right to nominate his associate, who shall be his running mate for the office of president. There is also nothing that invalidates the nomination of a new associate by a presidential candidate as his running mate after the withdrawal of a previous associate, so long as the nomination of the new associate was submitted to the first respondent 90 days before the election as mandated by Section 31 of the Electoral Act 2022. This contention of the petitioner is therefore discountenanced. It is therefore my view that, that the position of a person as vice presidential candidate not being subject to primary election, the provision of Section 33 of the Electoral Act 2022 does not apply. On that note, I hereby hold that the petitioner failed to prove the lone ground of his petition to the effect that the third and fourth respondents were not qualified to contest the election held on 25th February 2023 for the reason of double nomination. Having resolved the sole issue of this petition against the petitioner, this petition held to be devoid of any merit.
All right, these are live images at the courtroom in Abuja, Federal Capital Territory. And we are, of course, live at the Election Tribunal. It is decision day as we await the outcome of the petitions from Atiku Abubakar of the People's Democratic Party and Peter Obi of the Labour Party, the petition against the decision, or declaration rather, from INEC, Independent National Electoral Committee, that, of course, declared Bola Tinubu as the winner of the 2023 presidential elections in Nigeria. And so we've been hearing a number of reactions from the Election Tribunal to a number of those petitions. And we are awaiting the decision, which we will, of course, bring to you live. It looks like they might be taking a break, as we're seeing a number of individuals. They're all standing right now.
I'm continuing with petition number 3 and 5. I can see Dr. Levy moving up and down. So, as elderly person, I know what is going on.